check that microphone to see if it's on.
Should be on.
I meant to bring a battery. What kind of battery you taking? There you go. Not, I'm thinking.
Probably go dead then.
Just strike it on the agenda. There's no action, there's no strike it. It's not a special call meeting. Start with it. You can announce that if you want to. Seats for everybody sitting there.
He's here.
He is.
He's
That's
here.
him. Battery for best. On the top shelf. There you go.
Oh, there
See,
you go.
okay.
We'll go ahead and call this meeting to order. Roll call, please.
Managers Craycraft,
Present.
Pasley,
Present.
Constantopoulos,
Present.
Blanton,
Here.
Davis.
Present.
And Miller.
Here.
Pastor Mike Smith from the Church of the Living God will lead us in our invocation, and please remain standing for the Pledge of Allegiance.
Good evening to each one. Let's pray. Father, we thank you for your love, your grace, and your mercy. For without you, we are nothing. And Heavenly Father, you said that in your word that if we'd ask for wisdom, you'd give it to us. And Father, that's what I ask you to do for each one of us, including this physical court and each member. God, that you give us your wisdom. Lord, that each one has the mind of Christ in the decisions that they make, the words that they speak, Father, the thoughts that they think. Father, let decisions that are made in this room, in this physical court, bless the city of Winchester and Clark County, and Father, that they will ultimately bring you glory. And Father, we thank you for that. And we pray that each one under the sound of my voice will be ready for that day that Jesus Christ returns. God, we give you praise in Jesus' name. And everybody said,
Amen.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Yep.
If you'll take a look at your agenda, we're going to make a few changes here. Somehow I forgot to put the public comments on there, but it'll be after item 4. So 4A, you can strike out item 12 on the agenda. That won't be needed tonight. And then also, because of the number of people here, we'd like to move item 14, excuse me, item 14 up to right after the public comments, if that's okay. So the next item on the agenda is going to be...
Do you need to go ahead and do item 10 and make it?
Oh, I'm sorry, one other
Sorry.
quick, thank you. One other, on item 10, instead of a discussion, that is going to be the first reading of changes in the administration code for the Clark County Fiscal Court. I think we covered them all. Okay, so we'll get started on the public comments, and I'm sorry, Chief Asbury.
Thank you, Judge. I'll be brief. If any magistrate would like to, I have left a packet for you each. At the end of the meeting, if we have time, we can go to make a motion to go to closed session for property acquisition. I'll discuss the packet with you at that time. Thank you.
Thanks, Chief. Okay with that?
Yeah.
Everybody good? So it looks like we will be adding at the end, that we will be going into closed session to discuss item B, property acquisition. Will, Mayor?
Thank you, Judge. Magistrates, I simply signed up to present myself, to answer any questions. We are here tonight, obviously, to have the second reading of an ordinance concerning utility-scale solar facilities. Since that first reading, I've spoken to a number of you to address specific concerns. You will see in this second reading that those, I hope, are addressed. But if there are any further questions, I'm here to answer them. Our counsel, Tom Miller, is here as well. So we are at your disposal. Thank you.
Mr. Hendricks?
Good evening. John Hendricks, 26 Manor Drive here in Winchester. When I was last before you, I had not seen the ordinance. I've had a chance to review the solar ordinance and frankly have a couple of concerns. First, I know there's been comments that this has to be passed because of House Bill 4. I've had a chance to look at House Bill 4. Frankly, I think it's on shakier ground passing it before the legislation even goes into effect and referencing a statute that is not even in effect. But even that issue aside, this fiscal court could pass an ordinance at any time, and that would have to be considered by the siting board. In fact, the opinion I got today, and again, I'm just a small-town country lawyer. I talked to Frost, Brown, and Todd over in Lexington. Their interpretation tends to be the same as mine, that even if a plan was submitted, had gone to the siting board, but construction had not begun, this fiscal court could still pass an ordinance regarding setbacks and restrictions that they would have to follow. The other thing I will point out to this court is utility companies are not subject to this ordinance. This will only push out private companies that this court in planning and zoning can regulate and place it in the hands of the Public Service Commission. So that's my first concern. My second concern has to do with the ordinance itself. There's a line in there that blanket says no solar and agricultural zone lands. So the rest of the restrictions only apply to industrial or other zoning classifications, and the setback is set at 1/3 of a mile. So what this ordinance basically says is if Ford or Toyota or some company comes in and wants to put solar power like we've seen in the new Ford project, Clark County's closed for business. I don't think that's a good idea. My other concern is that this ordinance, and hopefully this gets changed because I think there's some legal issues with it, essentially says that a future physical court cannot grant variances or change the terms of this ordinance. I don't think one physical court has the ability to bind the actions of a future physical court. So what I would hope is we've had an extensive process. Planning and zoning has been working on this issue. I don't think there's this need that's being created to rush through this issue. Finally, the revenue side of this, if a public power company comes in here, the county gets zero revenue, okay?
What was your last statement? Say that again.
If a public power company comes in here, we get zero revenue as a county. Versus if it's merchant-generated solar, you'll get occupational tax revenue from the construction phase, and then a significant increase in property taxes, around $500,000, maybe $22 million over the life of the project to this county. We get to regulate it, and we get the benefit of it. Again, there's a lot of people in this room who I respect, who I know, who are against it, who are scared of it, and I understand that. But again, I want to point out, not passing this ordinance doesn't mean there's going to be solar in your backyard tomorrow. Nobody wants solar in their backyard, and I understand that. All we're asking is, let's have a chance to present a project, actually show where it is, to talk about setbacks, to have a conversation. Those issues would still have to go through the physical court. If you all say, never in agriculture, and you have to rezone and have a map amendment, that's going to come back before you as elected officials. So again, I would encourage the physical court, let's take our time and not do something in the long term that is a negative for this county. And again, I know they're happy to answer questions. I'm happy to answer any questions as well.
Thank you, John.
Kelly Nisbet.
Hi, I'm Kelly Nisbet, 19 Fairwood Lane, born and raised in Winchester. I have a real estate company here that has been here since 1979. I've also opened a real estate company in Georgetown, in Richmond, and in Lexington. I am a major investor and a true believer in something called RPAC. It's a Realtor Political Action Committee, because guess what? When you have people in Frankfurt and in Washington, there is no National Homeowners Association. There is no one that speaks for the homeowner. And so we as realtors take that charge on. And the thing that is most important for home ownership, well, most important for America, we say the pledge to, is home ownership because it's stock in America. The thing that is most important for homeowners is their private property rights on either side, whether you're for it or against it, of this solar decision. I think it's very dangerous to say never. Very dangerous. I think you can look at surrounding communities that have said never growth, never, no development. Very dangerous. And so I think it was a couple years ago, I was appointed to a committee that we were going to look at what we could do to make what the setbacks were, what it was going to be if we had a provisional use, solar use. Do you know we sat there for 3 hours and we disbanded before we set a second meeting because everybody wanted to kick it to the comprehensive plan. Everybody wants to kick anything they don't want to happen and let's shelve it into comprehensive plan. It costs taxpayers money because it's a lot of money to do the comprehensive plan. And then they think they can shelve it. And then they think it's not a living, breathing document, in which it is and should be used as. So I just say, when you all are thinking about these things, think about everybody's private property rights. Everyone's. Think of the danger of never, and think of the danger of NIMBY, not in my backyard, because it's all over. And it's got to go somewhere. And so we as a community can take the stance of helping it go someplace the way we would like to see it, rather than a power company's entity that comes in that'll do it just the way they want to, because they'll write to the Public Service Commission and they'll say they need this. We don't get any tax revenue. So that's all I have to say. It's just, please be very cognizant of the homeowner with big and small private property rights.
Thank you. Jeff Adams?
You're up. Chip,
He
you want to
said
speak?
no. He said no.
Okay. That is all of the public comments. Next on the agenda will be to consider approval of the minutes for June the 12th, 2023.
I thought we was gonna do 14 right after,
I'm sorry.
and we'll do all the other stuff later.
Okay. Gotcha. Okay, so the next on the agenda will be item 14, which is to consider a second reading of an ordinance relating to utility-scale solar facilities.
Motion to approve.
We have a motion. Is there a second?
I'll second it.
We have a second by Magistrate Miller, and we had a motion by Magistrate Craycraft. Is there any discussion?
Yes, Judge. The community has spoken overwhelmingly in favor of this, and I just ask that my colleagues join me and pass this ordinance.
Any other comments, any discussion? Sir?
Thank you. I wanted to address just a couple of the claims that,
Judge, I think this is inappropriate.
He had a point of order.
He's not a
Mr.
member of this body.
He's not a member of the body. He's not a member of the body.
the claim made by Mr. Hendricks was incorrect about
Okay.
utility
Yeah, we're
prospects. If,
Yeah.
could I clarify that? That just one?
I have to agree that that's,
Okay.
we had the public
In
comments.
that case, I'd like to submit, just for the record, if I may, an email that addresses that specific point.
While he's doing that, Judge, I did have a question for Magistrate Craycraft. I know when we took it up, Steve, on the first reading, there were two or three matters brought. I know Magistrate Blanton questioned a couple of things or had questions about a couple of items, and I think you all were going to revisit. Has there been any significant or minor change between first reading and this in the document?
I think the gist of the motion has not changed. There's just been a little more detail added to the motion. And a little change in the verbiage.
Thank you.
Sir.
To answer your question, Magistrate Davis, I did meet with Mr. Mayor, and we talked about 20 or 30 items, and there's a few of those that they felt they could correct, and they did a few of those. But quite frankly, if you read the first 6 or 7 whereases, and you get down to the 7th whereas, it says, whereas the local government of Clark County expressly intends and desires to prevent utility-scale solar development with the agricultural zone in order to preserve farmland, protect historic resources, and ensure that development is compatible with neighboring properties. And then we go into three more pages of how to regulate it. Well, we've already passed a moratorium and said we would not take it up till after the comprehensive plan was finished. So my suggestion would be that after this 7th whereas, we just put a period right there and add another sentence or two that says, we will review it again when the comprehensive plan is completed. We've got a moratorium in place. We have planning and zoning. This would reinforce that moratorium until such time as the comp plan is finished, which would prevent, in my opinion, any utility scale solar until we come up with a more definitive, more enforceable, something that we can, that doesn't have arbitrary numbers in it. Quite frankly, when I met with some of the Clark Coalition folks, you know, we've got some arbitrary numbers. We've got some things that really I don't think are enforceable. And we've been told time and time again we can't really enforce anything in an agricultural district. So in order to preserve our intent 3 years ago, not to have any utility scale solar until the comp plan is finished, I think 3.5 pages of this is really unnecessary to accomplish what we want to do tonight, which would to prevent any utility scale solar until such time as the comprehensive plan is finished. Again, Granted, we did try to meet and discuss some of these issues that I had. Some of them were corrected. But again, I think the big thing is, if the intent is to prevent it, we do that without another 3.5 pages that, and quite frankly, House Bill 4 was approved by the state legislature, so that tells you something. I mean, I don't want to make the same mistake they did by parroting a whole bunch of that same statute, because I really don't think it accomplished what they intended to accomplish. So I won't vote for this, but I would vote for something that ended after that 7th whereas and add some more language to it until we finish the comp plan. Because one, like I said again, we do have planning and zoning, so in my opinion, House Bill 4 is a moot point. And we've already passed a moratorium, and this would just reinforce that with an ordinance. And we've accomplished everything we've intended to accomplish.
If we add that to that, and we pass that, it still comes in before the 28th for people that are concerned for the 28th, right? And then it allows us to go back through this at the end of the comprehensive plan? Is that what we're saying?
In my opinion, it would be much simpler to amend a simple ordinance when the comp plan is finished, as opposed to something that states all these penalties and figures and setbacks and all the other things that's in here. But we've really already done this when we did the moratorium. So, you know.
The comp plan keeps getting pushed back. It was supposed to have been done, I don't know how many times, they postponed it or delayed it.
Doesn't make any difference when it's done. We've still got a moratorium, we still have a planning commission.
Well, we're looking at this HB 4 if we want to get this passed.
If we pass it, let somebody sue us. That's what the courthouse is for. If they don't like what we do, let them sue us. I don't think we have to go into 4 pages of parroting House Bill 4. It's just as easy for them to sue us if we pass a one-page document to support the moratorium that we approved three years ago. That's my opinion.
Any other discussion?
But there, well, I just have one, but there is that one line in there that I know that was questioned that Mr. Hendricks brought up, but I had the same question when I read that. But after reading it, I got the legal advice on that, and nothing can bound the fiscal court. We can change it at any time. So if there's additional project that comes up or something and they work with it, because my understanding is that this is, when they go through finish up the comprehensive plan, that eventually there's gonna be a text amendment that comes through.
Oh, sure.
Am I correct in that?
I would agree with that. I would agree with that. But that's why I don't think we need 4 pages of House Bill 4.
So what I'm gathering, what you're saying is if we do adopt this, we can still change it at another time or after the comprehensive plan, is that correct? If we sign that it
Yeah,
needs to be?
I'm relating to that one statement. I think that nothing can bind this fiscal court. I mean, we set the laws and we can change them at any time. That was the question that I had, and I asked it to both parties, but then also I asked the county attorney in regards to that statement.
Any other comments? I'm struggling with this because, number one, if we vote no on this, then I'm assuming that solar from these companies, it goes away completely. I'm assuming. Then if it goes away from them, if they go away, then what I'm hearing is, and I think it was mentioned earlier about the tax revenue, the structure there, the county has an opportunity to get money. If we let it go away, then I'm hearing, and this is where I'm feeling uneasy about this, I don't feel comfortable enough understanding all the ramifications of what's going to happen with House Bill 4. So if the solar company, and I assume it's down to 1 right now, if they go away, then we could end up at the mercy, the county could, of the power generation companies, they have the power of eminent domain, and correct me if I'm wrong, but they're not governed by planning and zoning
That's
to a
correct.
point.
That's correct.
So they could basically go in and pretty much do whatever they want to do. That alarms me more than the solar fields. Now, how do we control it? With the power generation companies, we have absolutely no control, my understanding. I think nationwide, I think solar is here to stay. How do we control it if it's coming? That's my quandary. The other thing that bothers me is that, you know, we've taken everything we could away from the farmers. We took tobacco away from them and we sent it overseas. Now, some of the smaller farmers, if we allow the solar to come in, there's only going, my understanding, as of right now, on the northwest side of the county, there's going to be one large solar farm. And the small farmers will not benefit. They can't be a part of that because I think the cost is inhibitive of what it would take. The cost to build basically a 1 acre is somewhere around $1 million. Takes about 8 acres to generate, I guess takes about 8 acres to generate pretty much 1 watt, so it takes a large amount of land to generate up in the millions of watts, thousands of watts. So what I would like to do for myself, I would like to have the time. I don't like running anything through quickly without feeling 100% that I have done what is best for the county. So I don't mean to be long-winded here, but I would like to see this. I would like to see it. A lot of people have put a lot of work in that comprehensive plan. I went to several of those meetings, and they're putting their heart and soul into it. And I think it is an injustice for us to jump ahead of that comp plan. I think we should at least wait and do what we had planned on doing in the beginning. So for these reasons, I'd like to feel more comfortable voting yes or no on this. So as of right now, then if there's no other comments, we're going to do a roll call.
Well, I have a comment. Unless you know something that we don't, this threat of the East Kentucky Power thing is something that they will not confirm or deny. So we don't know that that's a possibility. They're a big company, and then they may not even put solar panels in Clark County.
And I think that's what bothers me, is the fact that I don't know what they're going to do. I've heard those comments, and I don't like, on something of this magnitude that affects this many people in this county, I want to be 100% sure. And that's all I'm asking, is the time for us to do our homework, do our research, wait and see what the comp plan comes back with, and take it from that point on. Because I think, and you can correct me, that that regardless of when House Bill 4 takes effect, it overrides this. Go ahead. I want this question answered. Just 1 second, please.
Happy to. Thank you, Judge.
House Bill 4.
Takes effect on June 28th. What this ordinance does, as Magistrate Constantopoulos pointed out, it allows the county to come back after the conclusion of the comprehensive plan and change the zoning ordinance to fit what the comprehensive plan comes up with. What happens if this ordinance isn't passed tonight is the solar developer that I would mention intentionally brought an ordinance of its own making and worked on it for 9 months with the planning director, unbeknownst to the planning commission,
Back on
unbeknownst
House Bill
to
4.
fiscal court or the city commission. They didn't extend that same courtesy. What they could do is on June 29th, submit an application to the State Siting Board, to Public Service Commission, and it doesn't matter what this body passes subsequent to that, it will not apply to that application.
So,
So this ordinance, contrary, respectfully, Judge, this allows the local comprehensive plan process to finish and for the zoning ordinance to be updated to reflect that update. This preserves local control. It doesn't remove it.
Since I got brought into this, can I speak just real quick, because Will keeps confusing me with the other job. My client didn't prepare an ordinance, and our interpretation said the House Bill 4 goes into effect the end of June. That is correct. But there's no fundamental way on June 29th, all the prep work can be done and something can be submitted, plus there's planning and zoning. So it's not as if at the stroke of midnight, all of a sudden, there's gonna be a project presented and approved in Frankfurt. That's not going to happen. And even if it was being considered, this fiscal court could still turn around and pass an ordinance, and that would be considered by the siting board. And House Bill 4 is so vague, the legal consensus is even after the siting board reviews it, you all could still pass an ordinance up until they start turning dirt and arguably thereafter.
well, the fact that we have two different opinions here makes me feel uncomfortable. That I'm not a,
Can I give you a third opinion?
yes, sir.
We passed a moratorium.
Thank you, gentlemen.
We have planning and zoning. Whatever that House before intended to do doesn't apply to us anyway, because we've already passed a moratorium. We have planning and zoning. If we want to do something additional to that, then we pass this first 7 paragraphs and add another subject to the comprehensive plan like we did 3 years ago. In my opinion, we've already done everything we can do to prevent any industrial solar until such time as the comprehensive plan is finished. If you want to do the additional thing, let's pass this ordinance a second time, stop at that 7th whereas, and add another sentence about completion of the comprehensive plan, and we'll be done with it. That's my opinion, but, you know.
Excuse me, Judge, but you're still saying that if we pass this today as it is, we still get an opportunity to change it after the comprehensive plan is finished, correct?
Are we sure?
What did you were saying earlier, correct? Is that what you
I
were
mean, we
saying?
can ask the legal opinion. I asked I asked the county attorney that question.
Look how far I pushed my microphone away from me when I sat down. You can't legislate away your ability to legislate. Unlike the legislature, you're not called in to some legislative season. You're available anytime all year long to make any rule authorized by, the Constitution or the legislature. So, whether it helps or whether it hurts, I think that you could pass this tonight and have a first reading on a totally contrary ordinance next meeting time. So I don't think it binds you in any way.
I guess my biggest concern is, and I understand both sides, and just recently, this thing with the electric company, East Kentucky Power, has came up, and I don't know if to me, it's a possibility that could happen. I would be questioning that only due to the fact that they know how this county feels about it, and that would be not a smart idea to try to bring something in that the majority of the county doesn't want, just from a PR standpoint, and that's fine if they did. But on the other hand, too, is that to not pass something because we're afraid that something may come, and then allow something else to happen that the county doesn't want, or at least my constituents don't, or majority of my constituents don't, that makes me uncomfortable to try to have to make a decision on a boogeyman or something that could happen that we don't know for sure would happen. I mean, they got a lot of land out there in trap. Why would they want to buy more land to do that? But just a thought, if we can still pass something after the comprehensive plan and put something in before the 28th to eliminate that possibility, whether two different opinions exist or not, we can revisit it at another time. Is that correct?
We can do a first reading. If we do a first reading tonight, then we have roughly.
Well, this would be a second reading.
I'm sorry, this is second reading, so, yeah.
Well, it becomes law until such time as, I think what the county attorney, until such time as this body or the next court or the next court after that wants to either repeal it, amend it, pass a totally new ordinance, whatever the case. I mean, it does become law at the second reading, but as he said, I mean, we can't bargain away or legislate away the body's power to legislate, so. And as to the East Kentucky Power thing, I mean, I've heard those rumors and all that back and forth for a few months now. I have no idea whether there's any credence to it or not. I don't have any knowledge about whether they're gonna do anything at all with solar. I know they put the solar panels out there on the property next to, or behind headquarters on the interstate a few years ago. As far as anything out at Trapp or anywhere else in the county, I don't think any of us know anything conclusively, or at least I don't. It's speculative. It is to speculate on it doesn't serve us any good, and they are a utility. They operate under PSC. I don't think what they're gonna do or not do doesn't turn one whit on whether this ordinance passes or not. If they wanna put in 1,000 acres of solar panel and use that energy in the East Kentucky Power system or among the co-ops that own East Kentucky Power, there's nothing we can do to stop it or promote it. Now, whether or not, not having merchant power production in this county weighs any effect on East Kentucky and their board, again, that's speculative. So that doesn't have any bearing on my decision, and I don't think it'll have any bearing on anybody's decision. We just don't know enough about what their plans are. I find it hard to believe that this would have any influence on East Kentucky Power at all, but I could be wrong. So I just want to make that point, Judge.
Any further discussion? Roll call.
Magistrates Craycraft,
Aye.
Pasley,
Aye.
Constantopoulos,
Aye.
Blanton,
Judge, I'm going to vote no, but again, as I said, I fully support the intent to have a moratorium on any industrial solar until such time as a comprehensive plan is completed. I think all this ordinance does is parrots a lot of language from House Bill 4 that I think is unnecessary for Clark County. But I would still like to see us continue that moratorium until such time as the plan is completed and then take this up. I really think we're just adding additional regulation which are not necessary, so I'm going to vote no.
Mr. Davis,
Aye.
Miller,
Before I make this vote, I've got a lot of the people that are in my district that live there, and I see both sides to a degree. I've been hearing both sides over and over again, and I'm really down to what the law allows me to do as far as for my constituents, and I just got to stand with my constituents, and I get a lot more no's in my constituents that contact me than I do yes, and I would be a fool to vote against them, whether my personal opinion changes this or not, so I'm going to vote yes for this.
and Judge.
I have to agree with Magistrate Blanton on some of these comments. I would like to see what the comp plan, what it does say. I'll have to vote no on this.
5-3, motion carries.
Thank you. Good idea. I should have.
We've been through this time too, haven't we?
I'd just like to say that was a very professional, polite discussion and debate on this, and I appreciate all of it.
Okay. All right, moving right along, we're gonna go item number 5, consider approval of minutes for June the 12th, 2023.
Motion approved.
We have a motion by Magistrate Blanton.
Second.
Second by Magistrate Davis. Any discussion? Those in favor say aye.
Aye.
Any opposed? Motion carried. Item number 6 is consider the transfer list.
Did we have a transfer list on our desk?
I didn't see that.
Yeah, there's one here. Yeah, there's one here.
Where did you see it?
Oh, it's eclipsed with the
It's all,
salt
it's all,
contract.
it's all there together.
Salt bid, yeah. I see it.
Oh, with the
It's all
salt
there
bid.
together.
Oh, I got it. Make a motion that we accept the transfer list.
We have a motion to approve by Magistrate Miller,
Second.
second by Magistrate Craycraft. Any discussion? Those in favor say aye.
Aye.
Any opposed? Motion carried. Item number 7 is the bills list.
Motion to approve.
Second.
We have a motion by Magistrate Davis and a second by Magistrate Pasley. Any discussion?
Yes, Judge, I got one discussion. I know that noticed in the documents laid on our desk that there was an addition payment to be made, and it was for $6,385.95 to Civic Plus, and that's the company that does our website, hosts the website and everything. And my question, Judge, is that this bill is already late. It was due on June 18th, but we've had it, it was emailed to the finance office back in May, and I'm just trying to figure out why we're just now paying this and paying it late.
Well, mainly because we've contacted them probably 10 or 15 times. And what happened, there was a big discrepancy between, according to the contract, it was supposed to go up 5% or so a year, and for some reason, there was like a 25% increase. So and they have changed employees. So we've actually been going back and forth, emails, phone calls, for probably the last month with them. So I think here a few days ago, we finally got an explanation that, that this bill was accurate. So that's why we're paying it now.
Thank you.
Any further discussion? Those in favor say aye.
Aye.
Any opposed? Motion carries. You have a pre-authorization bills list in front of you there.
No, we voted on both the 8th and the 19th.
Oh, okay,
We don't have to
pre-authorized,
vote
okay.
pre-authorized.
No, we do that first of the year.
Yeah,
Perfect.
No
they're
comments, okay.
they're pre-authorized.
Pre-authorized.
Item number 9 is a note in the minutes for the Winchester Clark County Industrial Authority for the week of June the 5th.
Judge, I would encourage the members of the court, if you haven't been out Rolling Hills Lane, I would I was out there 2 or 3 weeks ago, and then I went out again today. You know, work on both sides of the road, foundations going in, dirt being moved. A lot going on out there. I would encourage you all to take a drive out there. And I'd had someone ask me at the Beer Cheese Festival what was going on out there, and I tried to explain it to them. They said, that's an awful lot of work. So I would encourage you all to.
That build ready site that they're clearing the property, I drive through that multiple times a week and watching the progression of getting that build ready so we could potentially advertise it is really big. And I saw that there was some for lease signs up. They're building some buildings.
You've got
Hopefully
brochures, you've got brochures, and you've got foundations in over at Tierney sites. I mean, it's.
Yeah, but I saw the signs go up for leasing that property too.
Yep.
I think this week they went up, so
Yep.
hopefully we'll get some business out there. Good to hear.
Smart
Good to
move.
see.
Any other comments?
Thank you,
Item
Brad.
number 10, that is going to be the first reading of some amendments to the admin code for the Clark County Fiscal Court. And I think everybody has a copy of those changes, I think. Or should have.
Which is that? Change.
And Judge, it looks like the majority of the stuff, the corrections that were presented here were a lot of housekeeping, procedures as far as where information goes. I know a lot was in there with the HR director and clarifying that kind of stuff, so pretty simple.
Judge, if I may, Steve and I were on the road committee, and we had talked at our last meeting about making some adjustments in the road department's starting salaries. And I know you've got some made in here, but the road department didn't get submitted. I didn't make the motion because they were special meetings, and I didn't know if we could make those. Can I offer this as an amendment to?
Well, let me see if I can answer that different. What I have been talking about, actually, this admin code since February. What I would like to do is, and the HR director and I have sat down, and what we want to do, two things. Number one is see if there's things in here that we don't need in there anymore. For example, we've got it's on page 18, one of those sections talks about clocking in 7 minutes before, 7 minutes after. We don't do that anymore, so maybe that needs to come out. The other question I have is, how many things, is there things that we need in there that's not in there? So what I would like to do, what we plan on doing, is we're going to go through this admin code. Our goal is to have something before you, let's say by September, October, so that we don't rush through it and make sure we include everybody in the discussion. And we want to go through with, everything in here with every department. And let's try to get, this is about, I think it's 2 years old or something like that, and try to bring it up to speed. So I'm agreeing with you. We need to get everybody's input in there.
All right, so can I offer this as?
Well, I mean, I've got 16 questions on these changes, just myself. What I guess, do we have to pass this tonight, is my question.
Well, we have to if it's going to be anything to do with what the magistrates want, because we have to do it in June. And we have to pass it tonight in order to pass it in the second meeting for second reading to be done.
I think you can change the admin code anytime,
We
but I think
can.
statute requires you to at least review it in June. But I think you can still amend it at any time.
I don't think that the magistrates can, from what my understanding is. Is that correct?
I mean,
The judge can change it anytime.
The statute that I always hear at the conference is that, in June, the fiscal court can look at it and make the changes.
The rest of the year, it's the judge has
The
to
rest
be
of
on
the
the
year,
motion.
it's the judge has to propose any changes. We
So if
can't
you had
offer
some
up
things,
any
Judge, like
amendments or
next
anything
month.
that. We can vote his up or down.
Well, and that's what I'm trying, I don't want to rush into it, and my thought was, like I said, this is something that I've been talking about since February. Yeah, there we are. I thought she hit on me. But, 'cause I think we share some of the same concerns and considerations. We just want to make it workable. So that, and that's, I mean, I'm not really disagreeing with changes and whatever, but I just want to be sure that we do it right. And I think we've had several discussions, and I don't remember if it's February, but it was way back. And that's kind of a plan we've kind of come up with. And I don't know, maybe we will do it with a department head each time or whatever, but to get everybody's opinion, get everybody's input, so that when we do bring it back before the court, it should be solid. So,
I'm sorry, just one thing, and I agree, I mean, we can work on this on a monthly basis and make changes each month if we want to. I mean, I think that's the nice part about this document. But there are some things in here that we've made changes to that we need to change, because it talks about our payroll being Wednesday to Thursday, and we're actually now Monday to Friday. And so we've got to address several of those things. There's also some things in here that I think that are important to address until you get the time to completely submit all the changes that you want, Judge. I mean, I understand that you've got several that you may want to pull out and admit, but while we have the opportunity, I think it's important to address those ones that we need to. There was some stuff as far as advertising for new employees, that, you know, the HR gets all those applications. Once she gets those applications, she goes through and who meets those qualifications, and then passes those on to the judge executive for him to review and go through. I think a lot of this stuff that was in here was just house clean. From what I saw, was just some house cleaning. It talked about when somebody, I know that there was in the previous admin, there was, if employee was terminated, we were paying out sick time for that individual. Am I correct in that?
Right, yeah, and the current admin code, it was stipulated in different, it was conflicting. So typically the way it was reading is anybody that left the employment, whether they were dismissed, they resigned, or whatever, they still got 25% of their sick pay because of the way the code read. So we're trying to clean that up. Where I think in this code, we're gonna say, if you leave, the only time you can utilize any sick time is if you retire. So if you leave, you resign, whatever the case may be, you won't get any payout for your sick time. That's one of the big changes from this code, but it needed to be refined and consistent is what we're looking for.
We already have some changes in starting pays within the department, so are we not gonna accept the road department's changes, or?
Well, you know, and again, when we start looking at the comp plan, that's another item that we need to address. And then if you want to implement those starting pays in that.
the compensation plan.
It's
So
part of
that-
the admin code.
So they don't miss the comp plan.
Do you see what I mean? I don't know. I can't answer that question. I don't know.
Oh, I mean, I think you can make the changes if you want to make the changes tonight. I mean, if the body is good with them, because, you know, he made changes, he made the presentation in the budget that he was changing those starting salaries. If we're doing the admin code, you can do it, but you can, like I said, we can still amend it at any time after that. But I think if it's already going to, you know, in the budget, and we're going to reflect that, it might as well reflect it in the admin code.
Well, the problem I have with that is that I'm agreeing with that we need to look at those wages, but we really need to look at the wages across the board in every department. We talked to a gentleman the other day, wanting to hire him possibly as a custodian, $9.02 an hour. He said, no way. He would rather drive all the way to Lexington. So we definitely need to look at, but I don't know that we need to piecemeal it. I think we need to come up with a solid plan across the board and look at all the wages.
Judge, what do you think, I see the starting pay here for the custodian is $9.67, and this admin kind of restricts you, you know, to that amount. I mean, what do you think's a fair salary, or a fair hourly wage for that?
I think probably somewhere around the $12. 'Cause the problem is they can go to any fast food right now and make 15 an hour.
Why don't we change
Why
it?
don't we, let's change it.
I'm good with that.
Why are we putting it on the back burner to do this fall? You know? I mean,
Well, I'm not, maybe that would be the very first thing we do. You know, I'm not saying wait till fall, but I'm saying let's go ahead and look at across the board, that not just, you know, the road, everybody, the fire, animal shelter, et cetera, and see if we've got them all in line. Doesn't
Judge-
matter.
Oh, go ahead.
I don't know for what reason, but we were attempting to hire another employee at the animal shelter, and for some reason, they were a no-show.
And we just raised theirs what was
Right.
recommended to. I mean, it's in here 17, 15, and 13. So I mean, you know, we gotta give that time to work, but if you're having trouble hiring, janitorial staff, and you want to look and increase it, I mean, this document's hamstringing you on the starting wage. So I mean, let's go ahead and amend it now, and let's take that
Well-
to $12 an hour, if that's what you think's best. I
But-
get on board with that.
Well, like I said, I don't think we want to sit here for this amount of time, but I have, just on these changes alone, I've got about 15 questions. This admin code becomes the law of the county, right? For us. That we are supposed to run this court by, and I think it needs to be a little bit more precise, it needs to be a little bit more clear. For example, it says, one question I have, and I don't have the answer, one says the county code
Which one?
enforcement. The county judge is designated the code enforcement officer for the county. Okay? What does that mean?
I know when.
How do we enforce it? Is there penalties? How do we do that job?
I mean, it's enforcing the ordinances that we have on file. I mean, I know like when property maintenance, you know, I know that Henry had put out there at the time that this is before we had a county detective. Of course, we don't have a county detective anymore.
Right.
So the county detective used to be, you know, they would help out with county code enforcement on that. But at the time, the judge executive, before we had that, was acting as the code enforcement officer. Am I correct on that, Magistrate Blanton?
Well, that may be true, but I was even asked at one time to go file a complaint on a particular road. So I don't know, I can't answer that question. I just know that I was asked at one time to file that complaint as a
Let me-
magistrate. Anybody can file a complaint with code enforcement. You don't have, if it's a violation, you can go file. I guess you can still do that, can't you, William?
No, the legislature changed that rule, became effective July 2018. Law enforcement can issue a citation without taking.
Yeah.
William, could
Without
you
taking
say that
action.
again in that microphone? Because the people I hear that people that listen to us on thing can't hear us when we don't use the microphone. Sorry.
I mean, that was just one example.
Okay, well, let me go ahead and make a statement. The judge and I have talked after we did this, and I removed several things that were on here because he wanted to meet with all the different heads. Well, I'd already met with the heads on several of them, and other ones I didn't get responses back from. So I took stuff off of there that said, hey, that's probably fine, we can go ahead and move that to when you're doing this. But I'd like to go through and ask you, the question is where's your problems with what's in here? Because I don't see anything except one word that I'd like to change. And so I'd like to go back through and answer any questions anybody's got, because I don't think there's anything in here that's not appropriate.
What page?
On page 4, we talk about here in letter E, we were gonna change it from may to shall. And after talking with a couple of the fiscal court members on that particular subject matter, we'd like to take it back to may. Being wise, some people cannot make those interviews. They are working different times, they may have a difficult, but as an example, the problem that I ran into was when they were doing the IDA board last time, we had a lady that was an HR person, and I don't know who she is. If she can't be interviewed, then I can't vote for her. But in my brain, I didn't realize we could table that, which is fine, and then have her come back in at another time and be able to do that. So I'd like to take it from shall, which means they have to come in, to may again, and then we can just table whatever we need to do to bring her there. That's the only change I see.
Where are you now?
We're looking at page
E on page
4E,
four.
first sentence.
Oh, I see, okay.
From
Yeah, and
shall
that's-
back to
I got-
may.
I see
That's
what
the
you're
only
saying.
change
Okay.
that I want to
First
see.
sentence.
And
Yeah,
what I'd
first
like to
sentence,
ask is, you know, I know, Judge, I'm not sure how long you've had this and long enough to obviously write down questions, but we talked just the other day and I didn't hear anything from you. So to go back through and say this hasn't been thorough and it's not good, well, that's a reflection on Janet, because Janet's been through it with me. So Janet, you're not very thorough. So just to let you, I'm gonna put you on the whipping block because you did it with me. So what I'd like to do is go through and say, well, where's your questions and what's your problems? Otherwise, we need to go ahead and pass this, and then you can make alterations or reflecting, which I agree with, on some other areas. But if unless anybody's got a better suggestion than that.
William, is there anything as to the code enforcement in the 2018 statute, that would prohibit us from appointing via the administrative code, the county judge executive as the code enforcement officer?
There's nothing in the 2018 ordinance that would prohibit, as Magistrate Blanton suggested, anybody attempting to file a complaint. But we are, at the county attorney's office, we're just insisting that professionals make these complaints and not be neighbor on neighbor without investigation or interview, or at least giving the accused an opportunity to say whether or not they agree or disagree they violated the law. So I think maybe this is more than you've asked me, but I think that establishing a code enforcement officer, whoever that is, the judge or others, meets that mark. as
He
opposed
could
to
delegate that,
expecting-
could he not?
Huh?
Could the judge not delegate that responsibility?
Well, he could certainly do that if the fiscal court makes that
That's what I'm
available.
saying, that's what I'm
Right.
saying.
Sure.
I'm saying, sure.
Well, that was, the main question I had was, okay, I don't have a problem being designated the code enforcement officer. My question is, what's the mechanism for doing this? Someone comes with a complaint. Who do I call? Is there paperwork, et cetera? And that's what in here, and as far as I know, we don't have that written down anywhere on what a procedure would be.
Well, you'd go out and you'd do, in some cases, a drive-by, and you'd get out and look at it, and
But it's not written down anywhere.
But do you want that in your admin code?
No.
Not really. Is
I
that
don't- I don't
something-
know.
No.
Well, just to be sure that everybody's aware, you can look up the ordinances online, and there's a very comprehensive administrative hearing board, property maintenance ordinance that establishes the process, which very closely tracks the League of Cities recommendation on code enforcement, which even includes blighted properties, which many times are some of the issues that we have. So, to Judge's point, many times ordinances reflect more policy than they do procedure. But in this particular case, I think the procedure's pretty fairly outlined there.
But should it be in the admin code, or is it just, or are we just designating him as that the person that enforces it? I think that's his question, is that the question?
I think Mr. Elkins kind of answered some of that.
And just to clarify, I don't think that all this stuff is housekeeping. Like I've added something here that's number 9 on page 2. That says any meeting held by the county judge with State Department representative, private contractors, and vendors that relate to specific departments must include the head of the department if he or she is able to attend. And that allows both for transparency, it allows for the people to have also the ability to have the expert there of that department to answer any questions when they're dealing with that. And Judge, we talked about that before, and you were okay with that, and that's why I wrote this in here.
I don't know why I would have been okay. I mean, we've got two separations here. We've got one as the executive, and that is to complete the daily operations of the county. And, I mean, what is a State Department representative? I mean, I don't know, to me, this is too broad, too restrictive, and that would be one of the things that I would say shouldn't be in there.
Yeah, that was one of the reasons why I started this process.
Well, and that's what we need to do. We need to have everybody's input, and that's why we were saying, instead of rushing into something.
Yeah, but you're
let's-
saying rushing again, and I don't
We
agree
only
with it.
have
It's
one
been-
month a year we can, as magistrates, can do
Well,
it,
I
correct?
wish, yeah, I really wish we'd started this maybe 2 months ago.
Well, and either way, I told everybody that needed to get a hold of me, and I don't hear, you get crickets from some people, and some people responded, so how clear do we want to make it, and how thorough do we want to say that it's been done or not been done? Because I don't like the opinion that I've rushed in it, because then I'd like to have all those hours back that I was rushing so hard with. Maybe it was a marathon instead of a sprint.
Any further discussion?
I've got two comments, and I'll just throw them out there if I can find it. And the printed copy we received at the last meeting was kind of hard to go through and find the changes, and as was the electronic copy, but I did make a few notes. Let me make sure I got them on the right one here. I've got 3 different copies now. On the nepotism thing, I do know for a fact that the city recently relaxed that somewhat. I think it was particularly for police personnel to get qualified people in there. So I do know that they did relax that some on that. And to your comment about
What page are you on that?
Are you advocating that we relax it?
the city was having issue getting qualified policemen because they were related to other policemen. And they relaxed that where you could employ a family member, but you couldn't supervise them. I mean, so if we're having, and I don't know if we're having issues with that or not, but I just know that they was having that issue, so they relaxed that nepotism policy there. Just a comment. I'm not saying one way or the other. I'm just saying instead of making it stricter, they relaxed it some.
Well, I would agree. I agree with
That's what I'm asking
city
him.
did.
But I don't know if we're having that problem or not.
But everybody knows, I mean, we've been accused of hiring family members.
Oh, I know,
in
I know.
fiscal court, and that's completely further
Sure
from
it
the
is.
truth.
That's why
I would never be in support of laxing
But-
that. We've always had a nepotism
Which is thus the
policy.
reason why we
I
made
just
that.
bringing that.
I know.
change.
And then
But-
with
there-
regards
there's
to
been a delay.
holidays, I think President's Day was added.
It was added, thank you, Robert.
But in Juneteenth is also a federal holiday, and the city has also added Juneteenth, even though that's not a state holiday yet.
To make sure everybody realized we added a holiday.
Right.
So it's not just, we're doing a little bit more than housekeeping.
Yes,
Then
we definitely are.
Then another question I had, and perhaps Chief Asbury can answer me this. I do know that at some point in time, the fire department has started requiring a 3-year contract, and I've not been able to find that anywhere in any of our regulations. Is that,
Come on up, chief.
Sorry, sir. So, yes, we do require a 3-year
I can't find anything that, when we started that, or why we're doing that,
It
or,
was internally because we were paying for, EMT.
I know why it was done, but I couldn't find where it was approved. I mean,
Magistrate, we approved, if I'm not mistaken, we approved an order because they had given us a sample form and saying, because we had to agree to pay for the EMT class. Is that right?
That is correct.
Hey, we had
I
to-
believe at one point that it was brought before the fiscal court. That
if
was
you could provide that to me,
That was before me.
okay.
It was- it
'Cause
was-
I looked and I
was
couldn't
in-
find it.
It was in our first term.
I couldn't, maybe I didn't go back far enough, but I've looked and I couldn't find it.
So
And I don't know,
It
if-
would have been between 2018.
and I don't know if that needs to be in the admin code or not, I don't know, but I went back several years and I couldn't find it, so.
I'll attempt to find it.
If you can attempt to find it for me, because as I was looking through this, and I just couldn't find it. I think I might have had one more issue. Thank you.
Get out of the way.
Thank you, Chief.
Janet,
I might have
Janet,
had one more if I can
someone
find
just
it.
texted me and said you need to talk into the mic.
I had another one. I got it.
Is the mic on? Hit it. Is the mic on?
I do have one more.
Just tap it.
About county vehicles.
No.
Battery's probably dead.
Probably dead.
Okay, didn't we mention that last time that we needed to check batteries before
I
that?
meant to bring a battery this week.
Okay, so, there we go. Yay, okay.
With regards to county vehicles, I know some point in time we said they all had to be marked. We don't enforce that. That's another one of those things we don't require enforcement of, even though it's been codified. And it says about not having any private citizens in county vehicles, and I see them all the time in, I won't say which vehicles, but I see people getting dropped off at school and this and that and the other, and they're in-county vehicles. So I'm not so sure that that's really good for the employees, you know, because they're going to work, drop the kid off as I go. I mean, it may be.
You're suggesting relaxing that. You'd be in favor of relaxing it?
I mean, that's what's been done right now. I don't,
Well, I'm
if
just
it's not,
asking,
if
yeah.
it's not causing a problem, if it's not causing a problem,
Good point.
you know,
Fair point.
but if it's causing a problem,
Yeah, we just don't want the abuse, right?
huh?
We're just not looking for abuse.
Exactly.
Okay, well, how would you word it? I'm all for changing it.
Well, I'm just, you know, when I looked at this last night before, it said discussion, didn't say approval, it said discussion.
Yep.
So, and then,
Well, we
Those
don't
just-
want to relax that.
Huh?
That's a county property. I get, it's not a convenience. It's that that's.
Well, I
county
understand.
property. So we tighten that up.
I just in practice what happens.
I gotcha.
I mean, because we all see them,
You know.
But where's the
and if we don't, if
enforcement?
we want to restrict it, that's fine. You may make some employees mad, but
Well, I get it, but it's gonna cause,
I
cause
under-
problems.
I understand.
If we continue it, so.
I understand. That's
I
just
don't
whatever the
wanna-
court wants to do. I just wanted to
Okay.
bring it up
Okay.
because I've seen it before.
Yeah,
about
and that
our
was the
insurance?
reason that it was put in here, because people have seen it.
Okay.
So we either gonna
That's fine.
enforce, we're
If
either
that's
gonna
what we wanna
enforce what
do.
we do, or we're not gonna enforce
If
what we
that's what we
do.
want to do, you know, same thing with marking vehicles. If we're
Yeah.
not going to require the vehicles to be marked, let's take that out as well.
Yeah.
And I might have had one more. Since you all tell me this is my only chance, I'll take every chance I get.
Yeah, take your time.
Seems like I might have had one more if I can find it. Like I say, I had so many copies.
My only one was, and Mark mentioned it earlier, was changing the shall to may.
Yeah, and I have a couple things I want to point out after Master Blanton, because I want to make sure we don't.
And I misspoke when I said house cleaning
It's
procedures.
very
And that's
di-
my
but-
fault because there are other changes.
Because I don't want to say 3 months down the road, oh, I didn't know we changed that, because
Oh.
that happens sometimes.
Correct,
So
correct.
there's
Well-
just a few things I want to
Hopefully,
make
by all
clarify.
means, yeah.
Yep.
My last comment was on page 19. It says 6 months, and that was scratched out and said successful completion of an appraisal period. I mean, you can't get much more vague than that. I mean, I'm not so sure we want to get more vague or keep it 6 months, but nonetheless, that was my only other comment, I think.
What time, I did see that. What time frame is you're saying appraisal period?
Appraisal period, when your benefits begin, your appraisal period is over. So for an employee to get eligible for benefits, you have to work at least 60 days, and then it's the first day of the following month. So it could be anywhere between 60 and 89 days.
The employee knows that.
The employee knows that.
Okay,
So
okay.
once they get on benefits, they should be able to say, I can now use my vacation time and all those other benefits that are involved after they successfully complete the appraisal
Which
period.
is 60 days.
60 days plus.
89 days.
And so it's 60 to 89 days.
Yeah.
And so that's why you're saying the appraisal,
Appraisal
because
period.
it could be, that number can be off.
If it was a straight 60 days, I'd say after 60 days appraisal
Okay.
period.
I did have one more.
Okay.
Page 35, meal costs $40 per day. There's no way you can eat one meal for $40 anymore.
That's true.
So, you know, if you,
What page? Magistrate
page
Martin?
35 on travel, expense reimbursement, I mean, let's just put actual receipts and forget the maximum. If most people are gonna use their common sense and, or,
What's the state reimburse?
I have no idea, but I know you can't eat one meal for $40.
Well, and if you're gonna be turning in the receipt, you're not gonna be gouging it, you're gonna be realistic with it, so no one's gonna be out there too far. But
And I had one more on page 36 too. It said the county judge shall make all room and travel reservations. Let the individual make them. I don't know why we would want to.
What page?
Page 36, B, authorization. I can understand if we want to have out-of-state approval, like the city does perhaps, but to have the judge make all room and travel reservations, let's
Well,
get,
that's what's been in there.
I know, but let's get rid of it.
What about having the employee traveling, or that employee supervisor?
Well, I think, I would think the purpose is to contain costs. To make sure if it's coming out of the judge's office, that the cost is.
What about
Well, you
having?
could be approved by it, but you
Yeah,
don't have to
approved
make
by
it.
it. Maybe-
You don't have to
Judge,
make
how
it.
would
Maybe
you
judge
like
has
that?
final approval.
Do you
Let
want it
the
to come through
supervisor
you?
approve it.
which on the other hand too, is that can be addressed when you do your part, right? You can change that as you're working on your admin code changes between now and September, is that
Well,
correct?
and that was my point. There's a lot of things in
Oh,
here
There is.
that needs to be addressed.
But-
But I
but-
think your practice has been, the supervisor has been.
Well, I mean, but if, You see what I'm saying? Just like the other ordinance a while ago.
Yeah.
Let's either put it in there and do it, or not put it in there and don't do it.
That's a good point. If the supervisor has been doing it, do you see any problem with changing it from the judge to the supervisor? You okay with that, Judge? That takes that off from you, so the supervisor would make the
Well, I'd
travel
like to
plan.
think about that some. I know, do we want them staying in a five-star hotel, or, I mean? do
Usually
we-
if you go to a conference, there's a conference hotel.
Yeah.
Right.
But I say we leave it in there and then let the judge change it to how he wants to
Yeah,
change it.
Yep.
yeah, that's.
Are you good with that?
Yeah.
Yeah.
That's fine.
Anybody else have any other questions on here
I've
that,
got one other comment. This goes back to what the
Please-
city of
please do,
Winchester does.
please do.
The full, they have to approve out-of-state travel. I don't know if we want to get that picky or not.
well, but I'm really looking, Robert, for
Have you
anything
ever
that I've
seen
got
them, have you ever seen them
highlighted.
deny out-state travel?
I don't watch all the commission meetings. I just know they changed that policy.
I don't think I've ever seen them reject it, but
Does anybody have any questions on the alterations that we made that are in yellow? Because all the rest of it can be dealt with when he
Well,
does
I-
that.
I do want to bring up something on the comp plan, to make sure we are all in alignment with 8 and 9. Do we want to keep it, or do we want to take it out? That's the conversation we had a few months ago about the increments and raises. You give one person in the department a dollar raise, you gotta give them all a dollar. I don't think our practice has been completely that throughout the years, we've given raises here and there. I just want to know if we want to keep it in there as is, or do we want to modify it, or just take them out?
Well, I'll cycle back to what I brought up. We're moving some of the departments. We've got it in the budget for the road department, and the road department is a pass-through. This isn't even county tax dollars.
What, just
Now
since
is
you
the
brought
time
that
to
up, would
get
you
it
mind
done.
reading those off so we could just
Sure.
make a note of those? I've got it here, so.
So
anybody-
this is straight, the road supervisor, of course, is salary and is exempt. The assistant road supervisor, he suggested instead of $20.12 to $21. Maintenance foreman 1 from $17.38 to $19. Maintenance foreman 2 from $16.56 to $18. Mechanic from $15.93 to $17. Heavy equipment operator to $16. Light equipment operator to $15. The maintenance worker from $10.67 to $13, and then the admin to $15, which is congruent with some of the other departments.
And that's within the limits of his budget that we just passed.
Yes.
Okay.
Can we make those changes?
If we've budgeted that, I'm fine
If
with
it's
that.
budgeted,
You all tell me, I'm just.
Same
if
problem
you
with
give me
it.
that sheet, so-
All departments will put in a raise in their budgets. Are you allowing that for the rest of the departments also?
Don't we normally just allow 1% at the first of the budget year for everyone?
The other departments are in here, the road department's not. That's what I'm trying to.
it's the starting pay wage is what we're.
Starting pay.
Starting.
Starting pay.
We're not addressing the individual's pay, we're individual's classification increase.
But according to the comp plan on July 1, everybody gets 1%.
Right, everybody gets the 1%,
Everybody gets
and then on
1%.
their anniversary, they get the 2, and then anything over that, the court decides on.
Okay, back to, back to comp plan. If we're gonna implement these new wages for the road department, they also get the 1% on top of it, correct? Is that how we're gonna do it? Because once this is in the comp plan and it passes the end of June, July, the 1% across the board for those who are eligible will get 1%.
Well, they still get their 1%, because these are just starting,
These are
starting
just the
rates.
starting.
Just
These
the
are
starting
new starting
rates.
pay.
Yeah.
If we hire somebody new.
Yeah,
Right.
that's
If
the
we hire
starting
somebody
pay.
new after we approve this.
So if a road maintenance worker's hired July 2nd at $13 an hour, of course, he's not gonna get his 1% till, he's been here a year, so.
Okay, but again, we go back to question 8 and 9. If you're given this much raise, even though it's starting, you're making it, it's different. If you just look at the current road supervisor, what do they make? Are you gonna make those increments for the current employees?
don't
Once
think-
that the budget is passed, we will address those.
It's
Well, these
nothing,
just apply to new hires.
That's right.
These just apply to new
Does
hires.
8, 9 just apply to new hires? Because that's where you're.
Is what now? Say,
No.
Number 8, 9.
this is no different than what we did with the animal shelter. That's all we're doing is the starting pay to allow them to hire somebody at that rate. Just like the judge is hamstring, he said he's having trouble with janitorial staff at $9 an hour. Well, that's what he has to offer because of the comp plan. So, we can change that to his recommendation of $12 an hour, so that way he can try to help.
You want to change it to $12 an hour?
I'm fine with that.
I'm fine with it
Yeah,
too.
let's do it.
Custodial or custodial supervisor, which we're talking about?
Well, that's a whole nother issue. I think we need to separate.
I hate doing things on the fly.
That's my problem with this whole thing right now.
I didn't get
think
this
we-
comp plan to this morning, this changes.
I think I understand what you're saying too. If you hire someone in at $16 an hour, and I've been there for 3 years, and I'm only making $13 an hour, and
You
you
got-
just hired somebody making $3 more than me, why am I not getting a raise?
We've had this discussion
And
multiple
there's where I think
times.
she's going with that. Am I right or am I wrong?
Exactly right.
You're not
Well,
being
we
fair to
don't-
your other employees. You've got
We
to-
don't have that. I looked at all those, and the changes are pretty minute.
I mean, I'm just going with what you,
Yeah, we had all this discussion when we did the comp plan 7 years ago.
I mean, we just did the same thing with the animal shelter.
Exactly.
Exactly, and then you had a couple employees that were below that, and they got bumped up to what the current rate was. I mean, it's nothing different than what we just.
well, Judge, what do you on your office, county maintenance worker, county supervisor, custodial supervisor, and custodian? What do you want to set each one of those at? County maintenance worker looks like it's starting as
Well, I
1120.
would prefer not to set them tonight.
Okay.
I'd like time to.
Okay.
Because
Well, we've got the second reading, so between now and the second reading, you can evaluate what you want to set those at.
That's right, and we'll take it up then.
And then
You know,
we'll take it up then.
another question, just a little bit off your subject, is we give the employees 4 hours of vacation time a month, right?
8 hours of vacation, 4 hours sick,
4 hours what?
sick time.
4 hours of sick
Okay.
time, 8 hours of vacation.
Why, don't most places give them 8 hours sick time a month?
It varies.
I mean, just kind of an
Sometimes we
average.
used to, they changed it in the last code to 4,
So we used to give them 8 and
give 8,
8 and 8.
8 and 8, yeah.
I think that would be only reasonable.
That's why.
And more so, the sick time in today's society. A lot of people go to doctors a lot. And I don't know that 4 hours of sick time is enough.
Then the question is how much does it get abused also?
Well, that's a little
What
hypothetical,
did that
right?
calculate out to a year?
It's kind of like the East
I re-
Kentucky Power.
Remember, Robert, we went through this
Yeah,
whole
we
thing.
did.
I mean, the amount was like 12 days a year, was it not?
Something like
What's
that.
is it?
No, for sick time, you don't start accruing until after you've been here for three full months.
But I'm talking about just a full 12-month period. How much time is that?
4 hours a month or 8 hours a month. The reason we changed it was because so much of it was
That was 96 hours a year.
Yeah.
donated and
That's a lot of
not
sick
used,
time.
and it didn't seem like
Yeah.
it was necessary having that much sick time in the bank. So people were just giving it away.
Yeah, that's right.
So that's why we changed it to 4.
Well, I guess the question I've got is I'm trying to figure out with the stuff, the changes that we made that are highlighted in yellow. I know that I sent out a previous copy, according to what Robert said, that he didn't have enough time, but I sent a copy out that had even more stuff that was pretty clear. We took some of it to refine it, so it's not that you didn't have time to look at it, it's just we even took some stuff out to make it easier for this last time. It took me a whole 30 minutes to go back through and read the yellow parts that we had changed. So if you didn't have 30 minutes today, I'm sorry, but I'm just trying to figure out what is in here that you don't want, so we can take that out or change it, and, and we can be through that, but, because it always can be changed when he does his part area, so,
Well, we got to read it twice, correct?
Yeah.
yeah.
Well, I've got the first copy I started with, and I've got the copy that was laid on the table last month.
Yep.
And I've got the copy we got tonight. So,
Yep.
I mean, plus the one that was emailed out. So I've had 4 different ones to look at.
Well, and they were all the same thing, just a little bit different colors and refined
Yeah,
a little bit.
A little bit harder to find.
Well, yeah, but did you find that it was helpful for me to highlight it the way I did so you can get right to it and look at
Yeah,
it?
but I hate looking at it online. I
Oh,
like
okay.
to mark on my pages.
I'm with you, I'm with you. I'm with you on that.
I appreciate that, Jeff. You know me, huh?
Well, it's first reading.
But don't make me feel bad that I didn't get it out to you quick enough, because I did, you know.
Can I ask a question about June 19th? Has that even been considered about us being closed?
He just brought it up.
I know the Clerks Association put out an email about who all was gonna be closed on June 19th. And of the ones that responded, 42 clerks' offices was closed. Now, we were open, but there's no mail, banks are closed,
Mhm. So the city was closed.
the city was closed, you know, Howell County was closed, Fayette County was closed, I mean, just a lot surrounding. I didn't know if that would be something, since you already had precedence.
My preference is, both government entities ought to have the same holidays. Because when one's closed, nobody knows the difference, if the city or the
Are
county.
you offering that up to add June 19th?
Sure, I'll add June 19th as a holiday.
I'm okay with that.
I go along
I'm
with
okay
that.
with that.
It's a federal
There you go.
holiday, so.
It is a federal
You
holiday.
can't take mail, so.
That's exactly right.
Can't get bills, so might as well.
So we just giving the employees 2 new holidays tonight, correct?
Oh, we just became popular.
I didn't get it till today.
When you, sorry, when
What's
you
your
say, when you say
recommendation?
8 and 9, what are you?
That's the one we give the raises across.
Yeah, on the comp plan, in the comp plan, way in the back, all the way.
Oh,
down.
I see, I'm sorry.
So is your recommendation to scratch 8 and 9?
I'm asking you. I think it's a bad policy. I think it's an entitlement policy.
I think you're right.
I think
We had this discussion back
need
before.
merit increases after we go, yeah, I think you get a yearly cost of living, those things, yes, I do, but I think to just give somebody a raise because somebody else got a raise, that causes some issues.
So your recommendation would be to
My
scratch
recommendation
8 and
is
9?
that we start in this fiscal year to start giving out, in addition to cost of living raises, a merit raise. Performance evaluations need to be with every raise increase. We need to make sure people are earning the raises that they get.
That's correct.
That's my position on it.
We can discuss that, but I'm all for getting rid of 8 and 9.
I'm
Yeah.
good for that.
But
Okay,
we'll
that's fine.
discuss what you said
That's
later on.
fine, scratch it out, take it out.
I think the
Sounds like there's a
strategy is
consensus.
a little different. I just want to make sure because we didn't do what.
I know, I remember the discussions we had before. I remember them vividly.
Hey, y'all,
Okay.
Okay.
sure.
Are we good?
I don't know, you feel we're good?
Are we gonna get another copy of this?
Think about, I was gonna change the colors on it.
Yeah.
Judge, was there anything that just gave you absolute heartburn in the yellow changes?
Yeah, on page 2, number 6 and number 9,
Page 2.
that any meeting held by the county judge with State Department representatives, private contractors.
I think the judge on that, they were
Well-
just talking about grants. Like if a person comes in to talk to you about a grant for that particular area, the head of the department should be
It doesn't say
there.
anything in here about
Let's
grants.
put may
Uh,
instead of must.
May would be, I can live with that. I mean, for
put
example.
may.
Well,
I've
but
got-
May, then what if the judge decides not to
I mean, you can
contact the
invite
person?
the supervisor, if he chooses not to come.
But that's what it says.
That's on him.
That's what it says.
But it says must.
Yeah, they must contact them, but then they can show up if they can.
I think
I'm
it's,
not reading it that way.
is this in, like, say you have a state fire marshal wants to come in and talk about something with the fire department that the judge may set up, or, you know, the
Yeah.
state road department,
Or what about a grant?
or a grant that comes in relating to the,
Well, I mean, if somebody calls me and said they want to come in and talk, I can't say, well, wait, let me make sure I contact everybody.
Or suppose he
No.
just stops in.
It just stops in, happens a lot. But the main one, though, is, you know, the private contractors, you know, we've got a problem with the elevator, I've got to talk to somebody quickly. I think this
Well,
just
but I don't
kinda-
think there's any department on it. Is there a department over the fixing an elevator?
I don't know.
I know there's a department over the animal shelter. I know there's a department head over road department. I know there's a department head over the fire department.
Well,
I can
I think
concede
it will
with May.
strike 9
Okay.
I mean,
and
I can concede with May.
Yeah, let's just put May in there. I think, I can live
That's-
with May.
Well, does it defeat the purpose, though, of why we're doing it?
well,
What's the enforcement of it? You know, I mean, I see the point, I see the premise behind it, and I support it, but, I mean, we've gotta work together here on
Yep,
this.
okay.
It's a document together, and I'm willing to
Yep.
give in on that.
Okay. I'm easy with you guys.
And I think that number 6, I don't really know, I mean, I thought we kind of were already doing that to keep the fiscal court fully advised as to the financial condition.
That's a treasurer's report, isn't it?
That's a treasurer's report, and report to the fiscal court on a monthly basis any account issues with vendors. I really think we've got most of those finally cleaned up and resolved. And what I'm doing right now is I'm going back to Lowe's and actually Rural King, because I found out we actually do have an account, a billable account with Rural King that we can use to get some material from.
How about as a compromise on that, and I'll specify why I want a portion of this. Scratch out the report to the fiscal court on a monthly basis, any account issues with vendors, and provide financial documentation, and just leave it as, and provide any financial documentation as requested by
There you go.
any
I can live
member
with
of the
that. I can live
court.
with that.
So that way, if Magistrate Blanton
I
has a
can live with that.
question,
Well-
you have to respond and give him
Well,
the
he'd probably do it
information.
anyway, I would think.
But-
Steve.
Well, I
So
disagree with you.
you want to see a, you want to see proper documentation, you want to see a phone bill, right? Something like that.
If I want to see a phone bill, yeah. If I want to see a bank statement.
Well, I
mean,
think,
it's the
I do
authority of
think the
court.
word, I would just suggest if you, it's rather than have account issues, I would have account maybe disputes.
Daniel just said provide financial.
Just provide,
Scratch
that
the
way
fir-
any member
yeah,
can
yeah, just
provide
scratch the first
information.
part.
Yeah, that's fine.
Just scratch the first part.
The long and short of it is, if there's a dispute with a vendor that's gone on for longer than 3-4 weeks, the court needs to know about it. Because if we've got, I mean, these bills are supposed to be paid by statute within 30 days of receipt. So if we're not paying something within 30 days of receipt of a bill, we need to know about it, need to know why.
Well, and I think that has been happening from what I've been seeing, especially with me coming up to speed right now, getting a better handle on things. Just like the Lowe's account, it wasn't that they were not being paid on time, it's because of the Lowe's structure of their billing and our structure of paying. Because I heard years ago, a couple years ago, we paid by invoice, we didn't pay by monthly statements. So the bills got paid on time. And somehow we got away from that.
Yeah, and respectfully, I mean, the way that the bill, the statement we get on the 1st for the Lowe's bill, and it's due on the 15th, so there's ample time to pay that statement when it comes in.
If we can get it on the 1st.
And, well, I mean, the copies you provided has it stamped on there when it comes into the office. Well, the previous months prior to you coming into office, that practice stopped. So on the previous months, they were all getting in here on the 1st or the 2nd of each month, and they have a due date of the 15th. But regardless, I don't want to deviate off that subject. I want to stay true to this.
Yeah, I'm fine with your.
But if that takes out, he doesn't want to have to report all this to
Yeah.
us, but just as requested by any member of this court, if they request a statement or something, they provide it with no issue.
I'm okay
move
with
on.
that.
Can you live with that, Judge?
Yeah, I don't like it, but I guess I could live with it. Because there comes a point of this that, where's the difference between legislative oversight and executive duties of running the county?
Judge, because your executive duties with financials reflects on this fiscal court. And the statute clearly says is that the fiscal court is responsible for all fiscal duties of the county. So if I'm going to look at something and have to vote on it, and I need the documentation to review that, I have the right to do that. Just like the general public is. They can file an open records, of course. In fact, we had a previous judge where we couldn't get documents and we had to file open records for it. But I'm just putting it in here. When I send you an email asking for something, I just ask you to respond and send it to me. I'm not gonna request stuff. It's just when there's an issue, and like the email that I sent you, you made a statement that we had 15 accounts that were in trouble, and even alluded to another one, you didn't even respond to it. In a simple, hey, here's the information of these 15 vendors, I would like to know who those vendors are and what the issues were. And I think as a body, and as a court, we ought to have the right to know that.
So do we want to make that change in number 6?
Yeah, yes.
What did we decide to do with the code enforcement? Did we leave that in or let that out to the judge, make his changes?
I'll make
I guess it's actually number C, under 9. I thought it was 10, but it's C.
Nine, is it 9C?
No, it's just
10.
C.
Oh, C.
I thought it was 10, but it's C. We decided to leave that out till later?
Yeah.
We
Okay.
did decide to take it out.
Till
No,
later.
leave it as is, yeah.
Leave it
Till
in.
later, okay, all right. I think I'm through with my questions.
Well, the next one
I'll
I
shut
have,
up.
is on page 4, on E. I don't know how comfortable that somebody who's applying for a job, you know, we've even talked about, instead of having them appear before this court, but it would be nice if we had a meeting room large enough that we could all be kind of down there at their level and not make it as intimidating for them. It's got to be a little bit uncomfortable. So I think that we should, instead of shall require them, because, you know, you have their telephone.
We already changed
We
it
made
to
that
May.
to May.
We already changed it to
We
May.
changed that to May.
It's May.
Yeah, it's
We
May.
changed that to
Yeah, it's
May.
optional.
That was one
All
of
right.
the first ones there.
Yep.
Then item F, said no person shall be selected as a member of a board or commission or for an administrative position if the person holds or is employed that may present a possible conflict of interest. Number one, what would be a conflict of interest and who decides it?
I went through that thought process. My first route is asked a whole bunch of questions like that. But the fact of the matter is that there's a lot of other stuff like that doesn't have a complete explanation that I'd like to know on some of them. But this one here, we're just making sure that there's no conflict of interest, because that's what the constituents always say that there is, that you're hiring family or you're hiring somebody to a board or putting somebody on something that seems to be a conflict of interest, and we're just
Ultimately,
wanting.
we're gonna be the deciding makers of that because we either voted up or voted down.
Yeah,
Right. So, I don't know, why does that even need to be in there then?
Well, I mean, I think it's great, I think it's important to promote to the public that we're not gonna even consider any
That's
kind of
correct.
conflict of interest.
that's correct. That's the reason I put it there.
Then
That's
the, kind of in the same line on G, it said the fiscal court boards and committees shall be appointed by the fiscal court. And I'm not, what exactly is a?
I thought I thought it was supposed to say appointed by you, approved by the court.
No, the fiscal court committees that we create.
Oh, okay.
That we create.
That we create.
are
You're
the
talking about
boards
our
that
board.
we
Okay.
create,
Yeah,
You're talking
then
about
we
our
get
board.
those
Okay.
appointments.
The
He has his,
fiscal- okay.
he has his designated appointments
I
that
got
have to be
you.
approved by
Okay, I
the
got
fiscal
you.
court.
Has that not always been in there?
Huh?
No.
That has not always been.
Not
in
always
there.
been in there.
No.
I got you.
Well, that's,
I got you.
I guess I just assumed it should have always been in there.
Well,
Yeah, it's good
I
to
see
have
what
it
you're
in
saying.
there.
yeah,
Okay.
Because we've got several that we have created.
Yeah, I got you.
more than house cleaning. Or housekeeping, sorry.
Well,
I
that,
got you.
Sorry.
Good point.
So what would be an example of one of those boards? Is a sanitation district, is that one of them?
well, but that's governed by the.
Animal shelter,
Animal shelter.
fire committee.
We have fire committee, we
Road
created
committee.
the road committee, we created the,
Community fund.
community fund committee.
By the way, we need to put that on the agenda for August so we can.
It's coming up, isn't it?
Yeah.
So-
We usually do it in July, so we can do it in August.
Judge, what else do you have? What other
So
questions?
basically, it's all the boards that we sit on here locally,
Mm-hmm.
they're a creation of the fiscal court.
But, so we're getting away from me appointing, or me nominating and you appointing?
This is just for the ones that the fiscal court, they're governed by, we created those, the body created those boards.
But what are we doing right now? What, I mean, if someone gets appointed to a fire committee, let's say, if someone resigns or whatever, quits, what's the process right now?
Well, let's say Daniel's on the fire committee, and he says, I don't want to be on the fire committee, so he wants to be on something else. We just appoint another magistrate.
Yeah.
It's not these other boards, it's just the
Yeah.
fiscal court.
Right.
Yeah, and you're
And
part of
we've-
the, you're part of the
the-
fiscal
the-
court.
The court is always kind of acquiesced to what the magistrate's interested in.
Yeah, just like we did. I mean, and we've done it in every court. You wanna serve on the fire committee, okay, great, and then we put it together and then we vote on it,
Yeah.
just like we've done, always done.
I mean,
Something
you could sit there and assign them, but, you know, I'm sure you would ask them first what they want to do, I would think.
What other questions you got, Judge?
I've got quite a few. let's just go ahead and we'll just run it up the,
No, why don't you take the time? It'll take, it's not that many things.
well, it's gonna take some time.
Well, I mean, are we being,
You've made note of the changes we've
Oh,
already
we've
discussed,
made,
though,
but
right?
The next go-around is the second reading. The admin code that is in front of you will be the admin code.
Okay.
There'll be no colors, there'll be no highlights.
Okay.
That's the
Okay.
admin code, so if we need to make changes, this is.
Could you highlight it just so we know what we changed tonight?
So you gotta read the whole thing.
I,
So thank you so much.
believe me, I read the whole thing in 3 days, twice.
And that gives you another, what, week and a half to review it?
Yeah, just don't do it to us the morning before, please.
I'm sorry, yeah, we hustle on getting this done.
That was my problem. I got a new one this morning at 9 o'clock.
You're lucky you didn't get it last night at midnight.
Okay.
A general one was on page 12, section A. What is I'm trying to get to it to read it. It talks about family members. And I guess I was curious, which family member?
Well, the
How
only thing
close?
The only thing that under the
yeah,
section 5.5A, is that what you're looking at?
yeah,
Okay, the only thing that we changed is that we took out.
Took out recommend.
yeah, that's it.
That's the only
We just
thing
took the
we
word
changed.
recommend out.
Yeah, it's already, they just took out the word recommend.
That's it. Otherwise, it's already in there. Yeah, the yellow is just to get you there so you can figure out what's been done.
Another one that Janet and I talked about is page 15,
Yep.
515. And we're talking about the injuries and everything.
Well, but you're only looking at changing Judge Exec's office to Human Resource Director. It's just changing
Yeah.
where it goes. That's it.
Well,
That's all that's changed.
I think he doesn't want that changed, that's correct.
well, I guess here's what I was saying, that part of, towards the end, that we say all injuries should be reported immediately to the supervisor and within 24 hours to the county judge, HR director.
No.
At the end of that, we say, or as soon as possible.
As soon as practically possible. I mean, there
Well,
could be,
Yeah. The question is, Judge, do you want it coming to you or do you want it going to Human Resource Director? That's really the
Well,
question.
I guess part of my concern is that I think with an injury, especially an injury, I think the judge's office should be aware of it.
You want to be aware of it before
I'd
her?
take the last 4 as soon as practically possible, just make it within 24 hours.
That's it,
Period.
yeah.
okay, I'm
exactly.
fine with
Yeah.
that. And
Okay.
then why don't you say 24 hours to the county judge executive's
Or.
office and
That's what I-
human resources.
There you
So
go.
that way both
Okay.
departments know about it.
All right.
Say that
Okay.
again, because that's,
Okay.
Strike
So-
out or as soon as practical.
And take out as soon as
Take out the
possible.
last part.
And then leave in county judge's office and then put a and
Human Resource
Resources
Director.
Director. So both of you get notified of it because it's important both of you know.
Yep, I'm okay with that.
And this one, it wasn't highlighted or anything, but I was just glancing through it and.
Well, that, you talk about that one when you do it, because that doesn't apply to this one.
All right.
Yep.
Okay.
What's another one?
And it's already been brought up about what is that appraisal period. That was a question
Yep.
I thought
that was
a little
answered, yeah.
vague. And then on page 20, I think the 4 hours of sick leave still doesn't seem like enough. But you guys have already talked about that.
Yep. That's not yellowed.
And let me get over to page 35.
35?
Yeah, I guess that, I will say this, somebody mentioned out-of-state travel. In Frankfurt, the House leadership they have to approve all out-of-state travel. And they do make all the reservations for out-of-state. I don't think that's something I want to be involved in.
Right.
On what page? 20?
35.
B, authorization B. I guess I just, and I'm sure when they
Are you
get.
talking about authorization B or C for reimbursement? Because B's not even on here, so I don't want to talk about it.
B?
Yeah,
Oh.
you're talking about C is the reimbursements to either you or the finance
Well,
officer.
I
Put
guess.
that on your list for later on, some of these other things here.
Wait a minute. Okay,
Like
that
this
was.
$40 per
yeah.
day and some of this other stuff, because they need to really be addressed
Do you want it addressed for the second reading, or do you want
Yeah.
it addressed for
But
when he does it?
sometime.
When he does it?
sometime. I mean,
I just say let him do when he wants it.
that's fine.
All right, I'm good.
Well,
Was there anything else?
just looking out for the employees.
Okay, yep, I'm with you.
We're good? All right.
Nobody have any other questions that we can clarify or anything? Yep, no.
Janet took good notes, I'm sure.
She's excellent.
I will be watching this one again, I'm sure.
Okay, so item 10 is what's before you. It is the first reading of changes to the administrative code for the Clark County Fiscal Court, item 10,
First reading with the changes.
with the
With the changes,
changes
yes.
as we have outlined.
So I make a motion that we take the administrative code with the changes of the first reading.
Okay.
To the second reading, yep, second.
So we have a motion by Magistrate Miller, and was there a second?
Yeah. Constantopoulos.
Daniel.
And a second by Daniel Magistrate Constantopoulos. Any discussion? All those in favor say aye.
Aye.
Any opposed? Motion carried. Okay.
Thank you, gentlemen.
Number 11 is to consider an approval of an order promoting Jason Miller to a mechanic at the Clark County Road Department.
Motion approved.
Second.
Have a motion by Magistrate Constantopoulos, second by Magistrate Pasley. Any discussion? All those in favor say aye.
Aye.
Any
Aye.
opposed? Motion carries. We removed line 12. Then, next item is line 13, consider an approval in order to accept the CAECO salt auction for the Clark County Road Department.
Motion approved. Second.
We have a motion by Magistrate Blanton and a second by Magistrate Constantopoulos. Any discussion? Those in favor say aye.
Aye.
Any opposed? Motion carries. We have already addressed item 14. So the next item on the agenda would be to, we want to make a motion to go into closed session.
Can we go ahead and do magistrate comments real quick while everybody's here?
Oh, sure.
Because I know there's a couple other orders that were sent to us that we need to address. So everyone received the order from the county attorney in regards to the salary from the fiscal court actually needs to be decreased. And so he needs to be taken because that's mandated by statute, the maximum, the amount that they can make.
I think he's got that, is it the county attorney's office?
Yeah, that's on the, pardon?
You gonna come here asking for a pay decrease?
Is it the county attorney?
It's, yeah, the two orders that came through.
The next meeting, that's on the agenda.
Yeah, it's already on there.
It doesn't matter.
That's one less thing we gotta do if y'all wanna do it now.
I just didn't want the.
And the packets,
And then also because on the settlement, do we also have that one on there as well? Okay. Then so we'll leave that one for the special meeting then. He had sent out the order, we had a previous order because we were directed by the state auditor's office. Remember, the private county attorney had turned over a bunch of excess fees that were unauthorized, and they said that we needed to pay them back. We entered into an agreement instead of the county attorney requesting all that money back at once. It was paid out over a 5-year period. We did an increase for his employees. It was deducted. So now we've got to pay out that remaining amount by the end of the balance. So with the deductions from the payroll and everything, is that, I'll make a motion that we direct the payment of $30,502 as the fiscal 23-year budget year wraps up.
when
here.
did we become aware of that?
That was back
I
in.
mean, I've not heard, this is the first time I've heard anything about this.
Well, the previous county attorney had excess fees and was turning over, delegating to where they went. It was about $195,000 that when the state auditor came in and audited the county attorney, the prior county attorney's office, is that that money was illegally turned over to the fiscal court and should not have been done.
Then we didn't do anything for about a year, and I brought it up, and we,
And then the county attorney, instead of making us pay that all up front, entered into an agreement with the fiscal court, which is the order that was sent to you as well, Judge, on the email. And it laid it all out, and he said that the agreement is that we would pay
right,
$58,300 for a 5-year period.
right.
Now,
I remember that.
Was that part of the email with the county attorney's pay raises? or
No,
No, it was a separate email that went
Yeah,
out.
separate.
It was, I don't know, probably about noon today, 11 today, something like that.
I can't remember when. I
And,
saw it
Yeah,
just
I'm not
before I came
seeing
down.
that.
Yeah, so I mean, it's an order that we already had, and it was an agreement that we had already, there's an order on file to do it. We just need to direct that payment out. And that was for $30,500.02.
Can we just put that on the bills list?
Just to clarify, we budgeted, for it also.
Yeah, it's budgeted, yeah, this is
Just
all
put it
on
on
the
the bills
budget.
list, we'll pay it.
Yeah.
I think you see in the budget, it's 50, the
just
50
put it on
some
the bills
that's
list, we'll pay
deducted
it.
from the salary, so.
Yeah, just put it on the bills list, we'll pay it.
And so you know, the reason I went ahead and brought it up is because when you get into the new budget year, the money's not gonna be there.
Exactly.
Correct.
It's there this year, but it's not gonna be there next year.
So I offered up that
So you don't
motion,
wanna
let's
wait.
go ahead and pay
Yeah.
that.
Second.
So is it gonna be an order, or is it just gonna come on bill list?
I made a motion to pay it direct.
Yeah, it'd be
to
on the
pay it.
bills list.
To direct the fiscal court to pay that amount of money out of
To the county attorneys.
the 23 budget, or?
No, out of the
Current
current
budget.
budget, yeah.
Yeah, just pay it when we have the special meeting next week.
I just made a motion to do it, so we don't,
She can go ahead and cut the check, yeah.
Okay.
Literally, if you get to July 1 and you haven't done it, you're gonna need $116,000 next year to
Exactly.
budget that, so.
Exactly.
so there's a,
Second.
Yes. You and Patrick.
You need a motion on that?
He did, yeah. Daniel made a motion, Ernest second.
Hey, we got a second.
Perfect.
Can you repeat that, so exactly for the record, what are we voting on?
okay, I make a motion that we pay the county attorney's office $30,500.02 for our responsibility for restitution.
Okay. And who?
Does that sound good? That gives you the authorization to pay it.
Just to be safe, I'd probably change the word restitution to reimbursement.
Reimbursement.
The line item looks says on a reimbursement on per audit, so.
Yes, okay.
Yeah, let's not make up
Reimbursement.
other words. It says reimbursement per audit. We labeled it specific.
So we have a motion by Magistrate Constantopoulos
Thank you, county attorney.
Seconded by Pasley.
and second by Magistrate Pasley. All those, any discussion? Those in favor say aye.
Aye.
Any opposed? Motion carried.
Cut the check.
And then we handled the order, and the other order's gonna be on the next agenda, correct? Because that needs to be done by the end of this fiscal year as well. And then, the only thing that I had, the only other thing that I had is, I know we've had conversations several months back in regards to the website, and I know there's things that aren't getting updated on the website that need to be due. I know the alerting system is not being done. So I spoke with Janet, and she is willing to take on that responsibility with the new software that we were able to give her for the HR. It's freeing up some time, so she can go in there and make those updates, keep the minutes up to date, and get the things updated. So, and she's willing to do it at no additional amount of money for that. So I'd like to make a motion that we put Janet in charge of updating and keeping the website update, and also our email accounts, just so when we need new email accounts or need to get more data storage or what have you, take care of all that with it, because it's all kind of integrated into one.
I second that. Judge?
Okay, we have a motion by Magistrate Constantopoulos. Did you get enough information to write that down? Second?
No.
Magistrate Midler, any discussion? Those in favor say aye.
Aye.
Yeah, I'm opposed. carries.
And that's all I have.
Anybody else?
I've got a couple things. The road department included in their 2024 budget $1.75 per employee raise. This would be an adjustment up and above the step raises that we just discussed for the employees, and that would put them more in line with our starting wages. So I'd like to offer up a motion to support that the county road department employees would get a $1.70 hour adjustment taking effect the first pay period of the fiscal year 2024 budget.
Say $1.70 or $1.75?
$1.75.
$1.75.
Yes, sir.
And that's what y'all did in the road department, in the committee?
Yes, and that's what's in the budget.
I'll second.
Have a motion by Magistrate Pasley, a second by Magistrate Craycraft. Any discussion?
I'd like to have these personnel things on an agenda.
I think so too.
I mean, that's just, because we talked about this once before, bringing up public comments and magistrate comments. I thought we all agreed that we would try to do these things on an agenda item. So I would like to defer any of this to we have it on a published agenda, because the public needs to know. And I'll make that motion to table this until it's on the published agenda.
So with what we have right now, we have two. We're going to have, you want to make a motion to table it. Is there a second on that? No second. So we're back to the main motion. Is there any further discussion? Those in favor say aye.
Aye.
Any opposed?
Nay.
I vote no.
Not that I'm against the raises, but I mean,
Just the way it's done.
subject to our previous discussions, which we all agreed to, we put them on an agenda. If we're not gonna do that, let's just ignore that previous discussion. Of course, I said we've agreed to other things, which apparently we didn't do, so.
Well, I just want to clarify, this is going to be after we implement the new admin code? Is that the raises?
Yes.
Okay, so is it a merit raise, or is just, what are we going to call it?
I don't know. I'd like to see it in writing so I'd know,
We have a new code.
'cause I don't know.
What are we calling it?
That's why I voted no, because I don't know what we're doing. Mr. Pasley, what are we doing?
Across the board raise adjustment.
A merit raise, a
Cost of living raise?
cost of living raise, what do you wanna call
I
it?
mean, we just did it for the animal shelter so that they could hire employees and be more effective, and the fire department, so the same
No, we
thing
did
for
not,
them.
sir. No, we did not. I was waiting till this meeting, so we did not do it for the fire department.
No.
I had asked for 30%, and I was waiting for the budget, so.
Yeah, you're
to go
right.
through, so I did not, just to clarify.
That's correct, that's correct.
To go into effect the first pay period.
Well, again.
Don't ask me, I don't know. I voted against it.
I understand.
The admin code will change too, so there is no provision in that allows across the board raise. If it's gonna be a merit raise, then we need to have the performance evaluations if we want to implement the code, the plan that we'd like that tonight.
Yeah, but I understand where you're going with that, but we're making this prior to the code being
But
amended,
it's
so
not
this is,
effective.
but the decision is being made under our current
I
admin
understand,
code.
but the effective date will not change till July 1, because it is consistent with the fiscal year and the new budget, is that correct? I mean, if you say it's effective in June, that's different, but you're saying it's effective in June because of the budget, in July because of the new budget. The budget is that.
When the payroll week for the new fiscal year starts when?
Not a second. But that's the new payroll for July, so we are in a new fiscal year as of July.
see.
You're applying a raise from, you're applying it to the old code, that come July 1, you have a new code. So,
But it's already been approved and in effect, is what I'm
but
saying.
the effective date to me is what's important. I go by the effective date. I don't know, I'm just asking, if it's a merit raise, is it cross board raise, what are you gonna, how are you, what are we calling it?
You all vetted it out in the committee.
Across the board raise for every employee, an adjustment.
Does that answer your question?
I just don't know where, I don't see where it fits into the comp plan, the new comp plan. Where's the cross the board raise for any department in the comp plan?
Well, I think when you raise the starting wages, it's going, or when you raise the starting wages, that, you know, those employees there they've been left behind in the aspect of it. When you've got people that are working in different departments that aren't out on the streets, that are working the heavy equipment, you know, we're not even paying $17 an hour. I mean, I think that plays an effect.
I'd really like to see this in some sort of written format so I can understand it. I hate not understanding it, but I'm really getting lost right now. If Janet don't understand it, I mean,
I mean, I thought we addressed the road department in the comp plan. I didn't know this was coming later.
I didn't.
I just wanna say, if you're gonna apply the admin code to it, the current admin code or the new admin code? And if you're gonna say it doesn't take effect until July 1, I don't know why you even applied to the current.
To the old one.
because we just did that, and like, those, you went through them all.
So the way I think I understand it, and I may stand corrected, is the order that was just discussed and voted on would be an immediate across-the-board raise of $1.75 an hour for all the hourly road department employees to be effective immediately. Now, of course, that depends on when the next payroll drops. The quote-unquote new comp plan, and we did a first reading tonight, but that's not been adopted yet as part of the new admin code. That's pending approval of the second reading. But the across-the-board raise took place immediately. That takes place tonight. And that's to be applied to the next payroll, whenever that drops, if that's tomorrow or next week or within, well, but yeah, within this fiscal year. I mean, if it's, I don't know why not. I mean, the court speaks through its order, so we just.
I thought it was said because it was in the budget for next fiscal year. That's where I was going with that. The budget for next fiscal year, but you're applying it to this fiscal year. I just want to.
So there'd be, okay, so I see what you're saying. So there'd be one more payroll before that. When's the next payroll? Okay.
Yes, the last payroll is due this tomorrow.
Okay, so you can't get it on tomorrow.
That you make on this, on a pay period that we are on, will hit the new budget.
Okay, well then that works out.
Yeah, it'll be.
That works out fine. So all existing employees, effective tonight, got that $1.75 raise. It won't drop until the July 2nd
Okay,
pay period, right?
okay. Just leave it there.
All the employees of the road department. Because we know that's in that, we've established it's in their budget. So July 7th is the next, I'm sorry, I said July 2nd. Somebody had mentioned the 2nd earlier. I think, is that consistent with what your intent was, Magistrate
That's
Paz?
what our intent
Well,
was.
actually, the pay period ends on July 1st.
Right,
So let's just go real technical.
Okay. Well.
At 11:59 p.m.
okay. So are you clear on it, Alicia?
I'll leave it all next
Well-
Friday, y'all can figure that out.
Right now.
No, I'm not clear, I don't get it, but how we're changing, pay rates in the middle of a pay period, like, cause we're in the middle of a pay period right now. Cause it started on, like, Sunday, today's on Thursday, so we are 4 days into our pay period that you're wanting to adjust.
Okay, well, what if I made a motion to clarify and amend what we just passed, which is to say the $1.75 raise passed in the meeting will take effect in the, was it July 7th pay period, effective July 7th pay period? Is that, yeah, I don't want to catch it in the middle of a pay period.
So then you have to change the comp plan again.
You don't have to
In the
change the
middle of
comp
a pay
plan.
period, even though it gets paid out, yes, we've already paid our 26 on the pay periods in
Right.
this on the fiscal year.
Right.
So, any adjustment that you make during these 2 weeks, I will affect your new budget numbers. It'll be on the first
Mhm.
of your 26 pay periods, even though it is a work performed in this fiscal year.
Right, which
It's
is
just
less than
the way
this
that
now,
our
which
pay
will come
periods
under
fall.
budget anyway. So effective July 2nd,
Right.
the pay period begins.
Then going back to your
So
question, what do we
then
call it?
that becomes like Janet's question.
I don't think it will.
You have a new compensation plan as of July the 1st, which does not allow for an across-the-board raise. Because you took that out.
Well, it does,
You
because,
took out that A and B.
but you're getting ready, I mean, we're getting ready to across the board of 3% for the fire department. That they included.
That's what I'm asking.
Well, no, you included that in your budget
I
and
did,
the
but we
thing.
still need a motion to make
It's
that
built into
happen.
your budget,
It's-
though.
Well, we're going to,
Yeah,
well, I mean,
it's
we're
built
going
into your budget,
to,
so
I
we
mean.
can
It
still
was
do it.
built in last year, sir, that we didn't get it.
Well, no, you did get it,
No,
because
sir.
we
We
did
did
a
not.
9% across the board for everybody. It totaled with everything. Yeah, there
It was
was.
6.2, sir.
6.2
No.
plus the other 3% that
But
was
we
given
had
for
asked
longevity, which was 9%.
additionally for 3%. I don't mean to speak out of order. If I'm not being called on, I'll be quiet. I'm just saying, we did not get that 3% because we had asked to be included in the budget. That was separate. It was not included. But that's what we are asking for this year. But I was waiting until the budget was passed before we brought it up. So if this is the time, this is the time. I'm just waiting. I don't want to speak out of turn.
Well, I mean, I think at some point, I mean, the fiscal court, this body has the discretion. And so, I mean, if you're saying that you want to do a 3%, at that point, I don't think you're hamstrung, you know, if the court votes to support that as 3%. That's across the board, but what they're saying is that we can't do that anymore. I don't agree with that. Because, I mean, we've had the comp plan in place forever, and we've done across the board with Magistrate Button.
Can we not call it a merit raise, do it like we have suggested for the new comp plan? What I'm concerned about is now we're suddenly already deviating from the comp plan. Do we want to say, it's in the budget for merit raises or raises, can we not go through that process if we're gonna put it in the comp?
But I think this is in response to us raising the starting wages. I mean, when you raise the starting wages, you move people around. We have done it every department, chief, have we not?
The existing employees.
The existing employees, when we made a starting pay raise, we had to go through.
We took 8 and 9 out, that's what 8 and 9 address, we should take it out,
Exactly.
that's what I said.
But we have always made it, and it's been different amounts. This one is straight across. I mean, we can add it back in there if it's this big of the problem.
Let's make sure you wanna take it out, that was the conversation we were having, do you wanna leave it in, do you wanna take it out? We said take it out, so when you take it out, we said let's do the merit raises, so are we putting it back in, if that's what you wanna do? I just want a comp plan that's functional and that we utilize, and that everybody's on the same page, that's all I'm asking. This is not being on the same page, we have already deviated from what we just discussed. From the way I see, because it was in the budget, you had the conversation, it's not consistent with the comp plan that we have just said we wanna utilize.
We can clear the comp plan up, but it's the same thing that we've done for every department at some point, some way, shape, some shape or fashion.
How do you do that in practice? To say we've always done it is not.
No, I said that we need to make a correction in the second reading to make sure that we have the ability to do that, because this is not gonna be the last time that we have to address this issue, is all I'm saying is. So if we need to add that back in there, or add some type of verbiage back in there, then that's what we need to do.
Right now, you have a motion on the floor, Davis, to amend with the effective date of July 2nd, but there's no second.
Second.
Now will that take care of the pay period issue that we were discussing?
Well, that wasn't a pay period. I mean, if it's effective on July the 2nd, I mean, that is the beginning of a pay period.
Okay, right.
Still doesn't address the comp plan issue, but
Well, again, I reiterate the fact, and Daniel pointed this out a minute ago, we've just done a first reading of the admin code, and by the addendum to that being the comp plan. So between now and 29th, I mean, I trust we can fix that pretty short order, so. But I think we need to clarify for accounting purposes that this is gonna start effective July 2nd. So I appreciate you all bringing that up, clarifying that. This is just as to when this thing's gonna start.
So we have a motion. Was there a second?
Davis and Pasley.
Magistrate Davis and a second by Pasley. Any further discussion? Those in favor say aye.
Aye.
Any opposed?
Nay.
I'm good. Yes.
And I just felt nay because I hate going by the seat of our pants. I don't think I really fully understand what we've been doing with these two last things, so.
Okay. Any other magistrate comments?
I have any.
Oh, I do have one. I wasn't gonna bring it up since we're so long. I'll do it at another meeting. This is too long. I'll get it.
Nothing at this time.
I don't have anything.
I'll make a motion that we go into closed session per KRS property acquisition.
We have a motion. Is there a second?
Second.
Second.
Have a
Either one.
Magistrate Miller, second. Any discussion? Those in favor say aye.